Each side will have 15 minutes to argue. The appellant may reserve up to 5 minutes, and the appellees are you going to be split time?
I'm the only one to be arguing.
Okay, that's fine, thank you. You may proceed.
Good morning, may it please the court. The grant of summary judgment by the trial court in this case to the employer.
Yeah, I was just going to say,
Oh, I need to reserve time too.
Well, I need you to introduce yourself.
Sorry.
That's okay.
My name is Mark Owens. I'm representing the appellant, Mr. Brinker. I'd like to reserve 3 minutes for rebuttal. May it please the court.
And you had, yes, you're on the break. Okay, I wanted to make sure. Okay, that's fine, thank you. Now that we've grilled you before you even begin your argument.
Yeah, that's the fastest I've been stopped.
Who are you anyway?
Really?
You may proceed, sorry about that.
All right, may it please the court. The decision of the trial court in this case that granted summary judgment in favor of the employer is directly contrary to black letter rules of statutory construction, is contrary to Ohio public policy, and it circumvents the compensatory objective of the Ohio Workers' Compensation Act, which must be construed liberally in favor of the employee injured worker pursuant to section 4123.95 of the Ohio Revised Code. Now, the trial court erred in its finding that it lacked jurisdiction over Mr. Brinker's appeal for 3 reasons. The first reason is there's no rule, no statute, no administrative code provision which prohibits a claimant's physician of record, which Dr. Snell was the physician of record for the claimant. There's nothing that prohibits him from filing an appeal on behalf of the injured worker who requested that he do so. Second, there's no rule, statute, or administrative code section that specifically requires a Form R2, a BWC Form R2, to be filed by an individual in order to file an appeal on behalf of a claimant.
But if you don't file the R2, how is anyone to know who's actually representing?
Well, his letter of appeal stated that he was filing it as the representative of the injured worker. Now, Form R2, which I have that form here, actually, injured worker authorized representative. If you read the language of the form itself, it says, I authorize the above to be my authorized representative. The authorization entitles the representative access to my complete claim file, including medical and or other information contained therein, and to receive correspondence generated in the above claim. So we would argue the purpose of Form R4 is simply if you want to authorize someone to be able to access your claim file, your BWC claim file, without you having to do so and provide information to them, you can do so through this Form R2.
What if your client was treating with 2 different doctors, and each one of them thought that they had his consent to file on his behalf? One of them filed based on, I don't know, let's just make up something, rotator cuff injury, and the other one filed on behalf of him alleging, a back sprain. You can understand if he has not signed the R2 indicating that the authorization, that there's a problem here in terms of the agency knowing, well, who's speaking on his behalf.
Well, I wouldn't think that 2 doctors would file an appeal in the same order. I mean, I suppose.
Well, I'm making this up as I go along.
I think that'd be an extraordinary circumstance because normally.
But the point is, just whether you think it's realistic that it happen or practical, the point is, an appeal could be filed alleging 2 different things by 2 different people.
I suppose that's possible that that would happen. And then it would be sorted out at hearing if that were the case. If there were 2 appeals filed to the same order by 2 different representatives of the claimant, they would sort that out at the hearing and deal with it that way, I would think. I don't know that I've ever heard of such a situation occurring, because normally, whatever the basis for the order denial would be, the doctor who would have been the one to opine as to that medical condition or that specific injury would be the one that would want to file the appeal on behalf of the injured worker. And the third reason why the trial court erred is because There was exhaustion of administrative remedies. The appellant's physician did file the appeal on Mr. Brinker's behalf within the 14-day appeal period, and Mr. Brinker did file his notice of appeal with the trial court within the required appeal period. So there was exhaustion of administrative remedies. The only argument that the employer has otherwise is simply because they are arguing that the appeal initially filed by the doctor was not effective. Pursuant to rules of statutory construction, a court must give effect to the words used in a statute and may not modify an unambiguous statute by deleting words from the statute or adding words to it, which is exactly what the appellee wants to do in this case. They want to add words that are not there into the statute and to the rules to say that a physician cannot file an appeal on behalf of an injured worker. If the Ohio legislature wanted to include such a prohibition, it certainly could have done so. It could have written that into the rules. It could have defined representative in such a way that it would only be certain people, and it did not do so.
Well, that's one argument, but I shouldn't say the real argument, but I think the real argument may be just that it's not so much that the doctor can't do it, it's just that he has to do it the right way. Just like when anybody files an appeal, it has to be done the right way, and the right way may be that you have to have the claimant do an acknowledgement of who's representing him.
Right. I mean, that, although I would say, I don't believe all attorneys file R2s, and they represent claimants all the time in workers' compensation hearings. My understanding of that, the form, it seems to be oriented toward access to the file, not so much as a requisite to being able to appear or being able to file documents on behalf of the injured worker. We cite to the Bailey versus Republic Engineered Steels case, Ohio Supreme Court case from 2001 in our brief, which defines what liberal construction means. It means adopting the most comprehensive meaning of the statutory terms in order to accomplish the aim of the act and to advance its purpose with all reasonable doubts resolved in favor of applicability of the statute. The interpretation and construction should not result in a decision that's too technical or narrow to defeat the compensatory objective of the statute, which we would argue that's exactly what the appellee's interpretation does. As you know, the Workers' Compensation Act came about in order to find a way to provide employees with access to benefits through this system rather than having to have the injured worker sue the employer and go through the litigation process. This was meant to be a simple, inexpensive, and speedy remedy for injured workers. And when we apply the rules of statutory construction and we take into account the purpose for the Workers' Compensation Act, we submit that it's reasonable to construe the word representative as anyone that's authorized by the claimant to act on behalf of the claimant. That would include the physician, if the claimant so authorizes him or her to file appeals or file other documents on his behalf. And you probably know doctors routinely do file forms with the Industrial Commission. Outside of letters of appeal, they routinely file C9 forms for additional allowances. They file C84 forms for motions, various motions before the Industrial Commission. They sign and file those forms routinely. And we would argue that Dr. Snell was a party in interest as Brinker's representative at the time that he filed this letter of appeal. And when we think about a claimant who may, at this point in the process, may not have a lawyer, there would be nothing in that order telling them they have 14 days to appeal that would notify the claimant that they have to personally fill out the form and file it. There would be nothing in there to tell the claimant that they could not have a representative that they trust and who understands the form. And that's the reason why Mr. Brinker asked his doctor to do it, because he really didn't understand what to do. So Mr. Brinker would not have been on notice of this hyper-technical, narrow interpretation that the appellee wants to apply in this case. And I think it's important to note that even the trial court acknowledges in its decision. The trial court states that under defendant's interpretation of the statute, 4121.511, which is the appeal procedure statute, the attorney would not be able to file an appeal to a BWC decision as they are not technically the claimant or the employer. And of course, that is not what is meant, or not is what not what is intended, and that's on page 3 of the trial court's order. So even the trial court understood that this interpretation is unreasonable and is too narrow. We also cite to the Industrial Commission's resolution R04-1-01, which provided to laypersons the right to do certain things before the Bureau and the Industrial Commission. Laypersons are allowed to assist in the filing and administration of claims. They're allowed to file appeals. They're also allowed to file protests with the Bureau of Workers' Compensation. So the Industrial Commission, through this resolution, has acknowledged that they want to make this easy for the claimant. They don't want to have too many hoops. They don't want necessarily claimants to incur the cost of hiring lawyers. Lay people can do most of these things if they're not arguing law, of course. But they can do basic administrative functions and file forms on behalf of the claimant.
How much time did you want to reserve?
3 minutes? Am I at that point?
No, you
Okay.
have another minute and a half.
So prior notification of representation is not a prerequisite in any of the rules, statutes, or administrative code provisions. Prior notification of representation, not a prerequisite to file an appeal under any of those rules. And of course, the trial court couldn't cite to any rule other than bringing up this Form R2. The Supreme Court in the Miesse case, M-I-E-S-S-E case, notes that Administrative Code Section 4123-3-22A demands only that authorization for representation be in writing and signed by the authorizing party. It doesn't say it has to be Form R2. There's no requirement that this written authorization be in any particular form, and we would argue that the letter of appeal is evidence of written authorization.
But the claimant didn't sign that.
That's true. The claimant did not sign the letter of appeal. The Ohio Supreme Court has historically interpreted workers' compensation appeal filing requirements liberally. There are a couple of cases that I don't believe are in the briefs, but Wells versus Chrysler Court, 15 Ohio State 3rd, 21.
Counsel, you're at 3 minutes.
Okay.
Reserve.
I'll hold off on those.
Thank you.
Thank you.
Good morning. Thank you. Lisa Reed, Assistant Attorney General for Appellee Administrator of the Bureau of Workers' Compensation. It's the administrator's position that the trial court correctly granted summary judgment in favor of the administrator based on a clear-cut lack of jurisdiction and failure to exhaust administrative remedies. Brinker's application was filed on April 28 of 14. On May 20, the Bureau of Workers' Compensation published an order on the merits denying his claim. He was duly notified in writing of that order, and if you looked at the text of it itself, on numerous occasions in that order, he's notified of his appellate rights. He's given a statutory 14-day time period and did not pursue an appeal within that 14 days. Instead, Brinker later retained counsel. She filed an untimely appeal in June of 2014. That untimely appeal was then referred to the Industrial Commission. The matter was reviewed on 3 separate administrative hearing levels. Each hearing officer found that they lacked jurisdiction to hear the appeal because it was not filed by a party to the claim. Instead, in response to Brinker's argument that his attending physician's report sufficed as a notice of appeal, they found there was no jurisdiction. So the merits of the claim allowance were never addressed. Our statute...
So they said, the Industrial Commission said that the physician filed appeal was not sufficient to invoke the jurisdiction.
Correct.
And that was because it was not on an R2?
No, because a physician has no standing to appeal under the applicable statute and rule. And I was just about to...
Well, the physician, I'm sorry, but the physician, there's a difference between a physician appealing a denial on behalf of himself or on behalf, obviously the physician has no interest in it, but if the physician says, I'm filing on behalf of the claimant, isn't that different?
Well, I think what counsel was referring to on a C9, in that instance, the physician is essentially a witness. He's the treater, he's providing medical support for treatment or additional allowance requests. But in that instance, the claim has already been allowed, so the legal process has already been gone through, and the doctor is submitting medical evidence in support of a legal request. He's not making a legal request on a C9.
But what I guess I'm asking, I'm not getting my, I'm misleading you, I apologize. What I'm asking is, on the actual notice of appeal here, what did the physician say?
He provided medical support for why he believed the claim should
But
be
did
allowed.
he say, I'm representing the claimant?
I believe he said he wanted the claim allowed, but I don't believe that he indicated he was representing him legally.
Because I believe that's what he said, that he was representing.
No,
He's filing it on his behalf.
Correct. He might have stated he was filing on his behalf, but the text of the letter that he submitted was largely medical as to why he believed the claim should be allowed.
Now, I know you argue in your brief that a physician shouldn't even be allowed to do this.
That's correct.
But the court said basically the real issue was not that a physician shouldn't be allowed to do this or is not allowed to do this, but just they have to be identified as his authorized representative.
Right, the court made that point, but even in our view, even if he had filed an R2, the hearing officers would likely still have rejected the claim based on the statute and applicable rule, which provide that it's the claimant, employer, the administrator, or their duly designated representatives that can pursue an appeal.
But the duly designated representative then would go back to that R2, wouldn't it?
Well, okay, there are only certain categories of duly designated representatives who can appear. Number one is counsel. And I would make the point that in all workers' compensation claims, counsel are required to file an R2 in response to claims counsel's contention. That's absolute. Every single lawyer who appears in a claim has to file an R2. There are certain non-attorney representatives who are allowed to represent claimants and employers, and those are covered in the Industrial Commission resolution, but they are strictly limited to 3 parties. 1, union representatives representing claimants, or on the employer's behalf, a third-party administrator may represent an employer, or an employee of an employer, such as a risk manager, may represent an employer. But apart from those 3 strict exceptions, anyone else filing an R2 who is not either a lawyer or falling within those categories would be deemed involved in the unauthorized practice of law.
Well, and that is the Ohio Administrative Code you're referring to?
I'm referring to the statute 511B1, the Administrative Code Section 4123, 318A1, and the Industrial Commission Resolution R04, which I believe you have, on the unauthorized practice of law.
Thank you.
Arguendo, with respect to the point about the R2 as noted by the trial court, if Dr. Schnell had some way fashioned himself a union representative, which would be the only non-attorney representative of a claimant permitted, and filed an R2, then he would have received notice of the order. One of the main functions of the R2 is not to review the claim file, but to make sure that counsel or non-attorney representatives are duly copied on any decisions of the Bureau or the Industrial Commission. But the trial court made the point that he would have had to file an R2. I would also note that he never appeared at any of the Industrial Commission hearings. He never filed any appeals at any of the Industrial Commission levels. So he did not hold himself out as a representative of the claimant at any point during the pendency of the claim. So practically speaking, he didn't act as a representative either. In Ohio, it's well settled that where a statute confers a right of appeal, it can only be perfected in the exact manner prescribed by statute. Here, there was no timely administrative appeal, and the trial court held that it lacked jurisdiction. But in failing to appeal, Brinker also failed to exhaust his administrative remedies. We would ask that you look at Daniel versus William, a party seeking review under our appeal statute 4123-512 first has to exhaust all available avenues of administrative relief. That's a court-made rule of judicial economy. It prevents premature judicial interference with administrative agency, and it makes a record. That didn't occur here because, as I've mentioned, the merits of the claim were never addressed by the Industrial Commission at any level. because they felt they had no jurisdiction, there was no timely appeal filed by Brinker. And Ohio law is absolutely clear, a party can't be deemed to have exhausted his administrative remedies by filing an untimely appeal and then having subsequent administrative appeals rejected on that basis, and that's exactly what happened here. So Brinker failed to appeal, there was no merit adjudication of his claim, so no exhaustion of administrative remedies ever occurred. Brinker makes quite a few arguments in his brief. The one that I would address that seems to have grabbed the court's attention was the C9 issue. When a claim is allowed, there's a merit adjudication of the claim allowance administratively at all three levels, and a claim is allowed for a lumbar strain or a herniated disc. Then there's a designated physician of record who is recognized by both the Bureau and the Industrial Commission, and that physician of record then would submit various medical reports in support of any legal requests that might be made in the claim. And with respect to treatment issues, there is they call it a right of appeal on a treatment issue. But what we are talking about is a legal or quasi-legal issue relative to allowance of the claim. So Brinker is confusing the issue by suggesting that an appeal on a C9 is the same as an appeal on an allowance issue. And it doesn't, a doctor providing medical support for a treatment request doesn't contemplate a legal issue or legal representation. So we do want to point that out. He's confusing the issue, and I think trying to divert the court from the salient issue here.
So the doctor's submission under C9 is in further support of the claimant's claim.
Correct.
Medical claim.
The claim's already allowed, but you're trying to get him more treatment, say more compensation, different types of treatment, surgery, chiropractic treatment, and so on. That will be a C9 is a treatment request of some kind. And they use the term appeal, but it is not in the legal sense as it is implicated in this claim. So in closing, we would just note where a statute confers a right of appeal, it has to be perfected in the exact manner provided by law. Again, Griffith versus J.C. Penney. Brinker is suggesting that by implication you extend the statute 4123.511 or the rule 4123.318 to allow an attending physician of a right of appeal. We would say this is absolutely impermissible. It's not the prerogative of a court to fill in or interpolate. That's what's omitted by the legislature. And the authorities can be extended by judicial construction purely to suit his needs, born out of neglect of clearly what his own legal matters. He was duly noted and advised of his appellate rights 4 or 5 times in that initial BWC order. And similarly, I would ask that you look at Armstrong versus John Jurgensen. Our liberal construction provision, 4123.95, doesn't allow a court to effectively rewrite a statutory system in favor of the claimants and their counsel in order to assure them favorable results. That's simply not the case here. And in closing, I would just also note that it's something of a conflict of interest. In addition to not provided by statute or rule, it's a conflict of interest. The doctor is treating him, so he's essentially a witness in his claim. He is not his legal representative. So honestly, if a doctor did purport to file notice of appeal, he'd be in derogation of the unauthorized practice of law memorandum, and that is why the statute is written as it was.
And I can see that argument, but I'm just not sure I understand why it's different with the C9. I mean, I understand what you're saying, but he could be a witness there too.
With the C9, the claim is already allowed.
Oh, I understand that.
So it's just a treatment request. This, what we're talking about, is a legal representation.
But the treatment request can completely, how do I say this? Obviously, the allowance is already made, but treatment can be very costly, very, can extend the claim out for maybe many more years, can affect partial disability.
Correct.
Perhaps, all kinds of things.
Right.
So with your conflict of interest, I'm not sure, how that would be any different in that situation.
Well, I would just submit, first of all, the resolution absolutely bars anyone but a union representative and a lawyer from representing a claimant. So clearly, that would be the unauthorized practice of law. And I guess...
For the initial claim, you're saying?
Correct. And, well, all throughout, that resolution applies to any hearing. But with respect to a doctor, quote-unquote, appealing, what he's just doing is providing medical support for treatment or compensation he feels appropriate in the claim.
Thank you.
Thanks.
You have a little less than 3 minutes.
Okay. I think it's important to note that my opposing counsel didn't cite to one statute any specific language that prohibits a physician from filing an appeal on behalf of the claimant. And that's because there is no such language.
But she says that it indicates the, who can be your authorized representative.
Well, I think she was talking about the Industrial Commission resolution.
Resolution.
But it doesn't, it's talking about who can make legal arguments on behalf of a claimant, who can practice, law. I believe that there was nothing in there that provides an exclusive list of laypersons that can perform any administrative function or any sort of filing on behalf of a claimant. I would also note that the Bureau of Workers' Compensation docket did show the filing of a physician appeal. It's on the docket. It says physician appeal. So at least there was an initial recognition of that appeal, and it's on the docket within that 14-day appeal period. And Dr. Snell was not practicing law. He was not making legal arguments or legal judgments. He simply was submitting a letter indicating that the claimant wanted to appeal the claim, which is not the same thing as making legal arguments as to why the Industrial Commission was wrong, but simply to say the claimant wants to appeal, and he is submitting this on behalf of the claimant, indicating that an appeal is being requested within the 14 days so that a hearing would be forthcoming with the staff hearing officer. And I think it's also important to note that Frontier, the employer, actually certified this claim in the very beginning. So they certified the claim. I know counsel was making a lot of the fact that there had been an adjudication on the merits of the claim. Frontier, right off the bat, certified it, which if we look at what certification typically means, that means that once the claim is certified, it's seen as valid and correct to the best of the employer's knowledge. So I think that's an important point here. They weren't, at least initially, they were not disputing the fact that he had a meritorious claim at the initial claim filing.
Is he still employed there, or is that the record?
You know what? That's a good question. I'm not sure.
I was just wondering why they changed their position now, so.
Right. So in closing, I would argue that the plain meaning of the law it would be that a representative can be a physician or anyone who's authorized by an injured worker, and that none of the statutory provisions or administrative code provisions that have been discussed in both briefs or in today's argument exclude a claimant's treating physician as a representative.
Need counsel, you're on.
Okay. Thank you. I appreciate your time.
Thank you. We appreciate both sides' arguments to the court. We will take the matter under advisement. A written opinion will issue and be sent to both sides, and you can look at our websites. Thank you.